Hi, this is Attorney Kelly Longtin from Kelly Longtin Law, and welcome to our YouTube channel. Today I want to talk to you about whether or not your revocable trust will help reduce your federal estate tax bill. Now, many believe that once they set up and fund a revocable living trust, property held in the trust will completely avoid federal estate taxes after they die. In reality, a living trust does not provide any unique estate tax avoidance strategies. The primary mechanism for reducing estate taxes is the unlimited marital deduction and the charitable deduction. Apply whether money or property, sometimes referred to generally as assets, are held in a trust or held directly by an individual. The unlimited marital deduction allows the transfer of assets to a U.S. citizen surviving spouse free from estate tax, while the charitable deduction permits tax-free transfers to qualifying charitable organizations. These deductions are not exclusive to living trusts, but can be incorporated into a trust-based estate plan to ensure that assets are distributed tax efficiently. Now, before delving into estate planning, it is important to understand that estate taxes come into play only when someone gifts assets during their lifetime and at their death that combine to exceed a certain threshold value. This threshold is called the federal lifetime exclusion amount and is currently $13.99 million for an individual in 2025. Unless the trust maker and the trust maker's revocable living trust have combined assets exceeding this amount, there will likely be no federal estate tax due at a trust maker's death. However, for purposes of this article, we will assume that the trust maker's assets owned individually and in the revocable trust are valued at more than the lifetime exclusion amount. Now, keep in mind, if you live in a state with a state estate tax, you need to work with an experienced estate planning attorney to ensure that these concerns are addressed appropriately, as state estate tax thresholds are often lower than the federal threshold and may require some additional planning. Of the two planning strategies that I just mentioned, the unlimited marital deduction and the charitable deduction, only the charitable deduction tool is available to single individuals. With this tool, all assets in a person's trust left to qualifying charitable organizations will be removed from the trust maker's taxable estate. On the other hand, the assets left to non-charitable beneficiaries will likely be exposed to federal estate tax liability if the remaining assets exceed the current federal exemption amount. In other words, if your beneficiaries are your children, your brothers and sisters, your nieces and nephews, your best friend, another trust, or even a for-profit business, then the property they inherit through the trust could be subject to federal estate tax, depending on the size of your remaining estate. Otherwise, any property distributed to qualifying charitable organizations through the trust passes free from federal estate tax. Married couples have both the charitable and unlimited marital deductions available to them. The charitable deduction functions the same way as described above for a single individual. With the unlimited marital deduction, all qualifying transfers of assets held in your trust that pass to your U.S. citizen spouse after you pass will likely not be subject to estate taxes due to the unlimited marital deduction. However, to be deemed a qualifying transfer, the assets must either pass to the spouse outright or be held and administered in a special type of trust for your spouse's benefit. On the other hand, if you're married and you create and fund a revocable living trust and name both your spouse and your children as current beneficiaries after you die, the portion of the trust passing to your spouse, utilizing the unlimited marital deduction, will likely not be subject to federal estate tax, and the portion passing to your children may be subject to estate tax, depending on the value of the assets and the federal lifetime exclusion amount available to you when you pass. If you include one or more qualifying charitable organizations as beneficiaries, the portion passing to the charities will likely not be subject to estate tax. If a revocable living trust does nothing to reduce your federal estate tax bill, that cannot be done by holding the assets in your own name, why should you consider setting one up? Well, there's 3 good reasons, at least. The first is to avoid probate. assets held in your revocable living trust at the time of your death will avoid the court proceeding known as probate. Depending on the state of residence at the time of your death, this could save a great deal of time and thousands of dollars in legal fees and court costs. Another reason is to plan for mental incapacity. If you become unable to manage your affairs while you're still alive, the successor trustee that you name in your revocable living trust will be able to manage trust assets for your benefit without the need for court involvement, like the benefit of avoiding probate that I just discussed with you. Removing the need for a court-supervised guardianship or conservatorship could save time and thousands of dollars in legal fees and court costs, depending on your state of residence. Another reason is to keep your final wishes private. A revocable living trust is a private agreement that remains private after you've passed. In most cases, the only people who will need to know the terms of the trust and what will occur during administration are the trustee and your named beneficiaries. Usually this document is not required to be filed with the court, which will prevent strangers from knowing what you own and how you want what you've owned to be distributed and how you want it to be managed. For many people, a revocable living trust is the ideal way to organize their final affairs. While the estate tax avoidance tools used by a living trust are not exclusive to such trusts, they can be incorporated into a trust-based estate plan to capture the general benefits that living trusts offer and provide equally important additional benefits unrelated to tax savings. So if you're interested in learning more about a revocable trust in the state in which you live, please contact a qualified estate planning attorney to talk to them in more detail. I want to thank you for watching. I'm attorney Kelly Longtin. We practice in Massachusetts and New Hampshire. Please like and subscribe our page so you can stay in the know of estate planning and how some of the options that are available may benefit you and your family. I want to thank you all for watching. Till next time, I'll see you then.